everyone. My name is Christy Naylor. I am the Chief of Enforcement and Securities for the State of Alaska Division of Banking and Securities. We're in the Department of Commerce, Community and Economic Development, and we're located over in the Atwood building right here downtown. I'm trying to keep to the format of the Million Cups, and it's really hard to talk about something so big as crowdfunding in 6 minutes, but I'm just going to give you really the very high-level overview and then hope that people will ask questions afterwards. And just as a disclaimer before we get started, the Division of Banking and Securities, we have a lot of resources for you, but we don't provide legal advice. We can help direct you to where you might be able to get some advice, but we can't give legal advice. So there may be questions that I just can't answer, and well, suggest that you find an attorney to answer those questions for you. So what is crowdfunding? Crowdfunding is something that we've all heard of, obviously. Crowdfunding can be a couple of different things. The crowdfunding that's probably more prevalent that you know about is Kickstarter, GoFundMe. That's where it's essentially charity crowdfunding. People give money to your cause. It may be an entrepreneurial cause, but they're not getting any sort of investment for that money that they give. They're just giving the money to help your business sort of out of the kindness of their hearts. They may get some sort of trinket or something of value in return, but it's not an investment, so it's not a security. Securities regulators don't get involved in that sort of crowdfunding. Crowdfunding that we're talking about today is equity or debt crowdfunding. That is securities related, so that would be where an investor provides capital expecting some sort of return on investment. And the SEC regulates interstate crowdfunding, which is between the states, and state law governs intrastate crowdfunding. 24 states currently have crowdfunding legislation in place. Alaska does not, at this time, permit intrastate crowdfunding, but we'll talk about some potentials out there that are on the horizon. So currently, Alaska startups or expanding businesses can raise money in lots of ways without doing crowdfunding. And basically, there are a number of exemptions in the securities law that you could benefit from. There's a limited registration opportunity through the securities law, or you could do federal securities registration, be what's called a federal covered security, and then you wouldn't have to register in Alaska. And those are all things that you could explore with an attorney. It's really important to remember that the definition of a security is not just stocks, bonds, it's lots of different things. It includes promissory notes, debt financing, all investment contracts. And so it's really important, I can't stress this enough, to get an attorney on board with your entrepreneurship project early and make sure that you have all that in line as you're going through, because there can be problems that will result later if you don't have the securities piece figured out. So we talked about possible crowdfunding in Alaska. There is a proposed crowdfunding provision under a Securities Act update. It's a governor's bill. It's Senate Bill 108, House Bill 194. The division was very involved in drafting this legislation. Under this proposal, which is live and active in the current legislative session, the issuer would be an Alaska business. The investors would be Alaskan residents. Again, it's intrastate, inside the state only. People could raise up to $1 million total, of $5,000 per purchaser, limited unless the person is an accredited investor, which is something that's legally defined. Only licensed salespersons can receive a commission for this, so someone can't just sort of like drum up business and then get a commission on the side to help you raise money through crowdfunding. There would be a filing that's required to our office, and there's different timelines depending on when whether you do general solicitation like advertising or whether you're not soliciting. And you have to provide some disclosures to investors about your business, about who's involved in the business, and let the people know that these securities are illiquid, and the investor has to acknowledge that there's a risk associated with purchasing these securities, as there always is with any securities transaction. And importantly, there's a disqualifier that bad actors, as defined by Dodd-Frank legislation, basically, if you're a bad actor, you can't participate in crowdfunding. You can't have the special exemption. Bad actors would be people who have been convicted of securities fraud. That's a big one, obviously. We don't want them to have special benefits of getting these exemptions. People may have heard of the SEC's crowdfunding. In 2012, the Jobs Act was passed by Congress, and we've been eagerly anticipating SEC interstate crowdfunding rules since that time, and actually, as kind of a surprise, in October, they released them. You're welcome to go to the SEC's website and read the 600-page release on the interstate crowdfunding. What's important to note, and I have it in red here, it's not effective until May of this year. They're still getting some final elements in place, but it's kind of some similarities to what's being proposed in the state. $1 million maximum in a year, and there's investment limits. They're really complicated, but it's based on how much money you earn, and then it's like 2,000 or 5% of your annual income, whichever is greater, or 10% of your income or your net worth, whichever is less, depending on how much you earn. They also have financial disclosures that have to be given to investors, and those disclosures are really extensive. They have to give audited financial statements, and there's a lot of different, very onerous accounting requirements that go with this. And something that's very different from what we would be proposing in our crowdfunding legislation is that the transactions have to take place on an SEC registered, what's called a portal. So basically they register a new sort of entity to set up a website like a Kickstarter or something, but to do equity crowdfunding, but you have to do it through their venue. You can't do it in any other means. So they're going to be taking commissions off of that, so there will be costs associated to investors or to the entrepreneurs themselves. They're likely going to be the ones that will be paying to have their opportunity on these portals. So I mentioned before, if you don't get an attorney, there can be problems. What if I issue stock or debt that doesn't match up with the law? Good intentions, we always take that into account, but you have to follow the law. First of all, your investors could sue you. You could have potential legal action by us, the state of Alaska, or by the SEC, depending on what type of transaction it was. And the biggest risk is that, say your company gets big and you want to go public, or you want to sell it to someone else, a bigger investor, they see that there is a problem with the securities issuance way back when. It's basically like a cloud on the title of your company, and so you have to go back and unwind, and usually that process is through rescission, so you have to offer all of your investors their investment back plus interest. And so that can really take a huge financial hit for your business. So we really want to ensure that you are on the right path at the beginning so that you can avoid that, because honestly, we're here to support you all as well as entrepreneurs. We would like to see everyone be successful, and we're not trying to throw up roadblocks. It's just, help you navigate the path of the legal requirements that you have to meet. So here's some resources. Our website, we have a crowdfunding resources page on our website, and you can get the link there. And I have a link to our website on my business card too, so you can see that, or you just Google banking and securities and it'll come up. And the SEC has a lot of crowdfunding resources with their new Jobs Act crowdfunding that's coming up. So you can go to their website, sec.gov, go to the Jobs Act link, and check out crowdfunding links. And all the 600 pages of the rules and information is there. It's actually, I just went and reread it again, and even though it is 600 pages, it's actually fairly digestible. So if you have questions about the federal crowdfunding, that's a good place to go. Again, we don't offer legal advice. We have many resources. Contact us. Come to our office on the 18th floor of the Atwood building. There's an email there, and we're available by phone. So I know that I flew through that, but I think that gives a really good high-level overview. And if anyone has any questions, I'm happy to field those.
Did you say that you guys are introducing new legislation?
So there's actually two bills that are up about crowdfunding that are active in the legislature right now. One is a governor's bill that we worked on, and that's Senate Bill 108, House Bill 194. It was introduced in both houses at the same time last year, but it's still active. And then there's another one that Senator Costello has proposed that was just introduced a couple of weeks ago. They're both very similar.
108. So it's 108 House Bill and what was the Senate Bill?
It's Senate Bill 108, House Bill 194, and then the other one is Senate Bill 126.
And this is to allow interstate securities.
Yeah, it's essentially creating an exemption in the Securities Act so that you can do crowdfunding. The reason why crowdfunding is not something that you can currently do is because most of these exemptions prohibit you from advertising. Obviously, that's sort of what crowdfunding is like getting your idea out there. You want a lot of people to see it out on the internet or wherever, and then people to donate, or to invest. And if you can't advertise, it's sort of you can't really do crowdfunding. So this is an exemption that would allow, if you meet these criteria, you don't have to register your securities, which is a very extensive process. You get a special exemption just as long as you meet the criteria.
Two questions. One is, assuming that one or the other of these bills passes this session, when would you anticipate that the banking securities would actually be able to turn on the regulations to implement the legislation? And the second question tied with that is there any risk that the Alaska legislation will be contrary in some way to federal legislation and get ourselves tangled up in a knot for a while before we can actually use it?
Okay, so first question about how we can get it implemented. I know that the governor's bill has a proposed effective date of the next fiscal year, which would be July 1st of 2016. If we have indication that it's going to pass, and really we've been thinking about crowdfunding for kind of a while, that would be the first regulations, because they're brand new, the first regulations that we would work on. So I would think right around that time or shortly thereafter. Regulations take a few months to get through, but it would be certainly by the end of the year. So that would be what I would anticipate. As far as the federal, they're very distinct and separate. The SEC has current, in the securities law, has current requirements about intrastate offers, and that's sort of where these intrastate crowdfunding, the states have been operating under current federal law that's been there for a long time, about how you can advertise and what you can do, and you just have to make these assurances that you're not going all over the country, that it's really just within the state. I don't see that there will necessarily be conflicts, and we haven't seen any indication that there would be a problem with that. I know that with the SEC's rules, you can have other securities, you can be raising other securities outside of crowdfunding, and it doesn't go towards your $1 million cap. So I would think that might be sort of, I don't know if that was because they're thinking of other crowdfunding that you might be doing intrastate, or if they're thinking of other fundraising that you might be doing. But I wouldn't see that there's a conflict there.
Are there any restrictions regarding investor control, or more specifically dilution of shares? Or is it just kind of same as a standard?
So I'm not quite sure what.
Say I issue, at a $100,000 valuation, I issue $20,000 worth of common stock through crowdfunding.
Mm-hmm.
And then I take an investment. I mean, this is obviously extremely optimistic. Let's say I take an investment of, that gives me a $1 million valuation of $500,000. That $20,000 share suddenly goes down substantially. Is there any regulation that prevents that? Normally, as an investor, you'd be concerned about those things. You'd have checks on that, a seat at the board, something like that. But it seems like that's not the case here.
Not typically. It's really just anticipating that it is more like a Kickstarter raise. So it's, I'm doing, you set your valuation at the beginning, and then that's what it is.
So who's vetting the companies who want to start the crowdfunding? Can any company come and say, once this gets started, it sounded like there was maybe some regulation on who could be an investor, but is there any regulation on who can apply for the crowdfunding as far as to start a company?
So with intrastate crowdfunding, you have to be an Alaska business. Under both of the proposals, you have to be an Alaska business. You would have to have a business license, be registered in Alaska, so an LLC or corporation that already has their paperwork through the Department of Commerce, and again, a business license in Alaska. So there's assurances that it's not, a California business coming up here trying to benefit from intrastate crowdfunding. So it's really Alaska businesses and Alaska investors. And then there's, filings that have to be made about the advertising that they're giving would have to be, given to our office to review and make sure that it's compliant with state law. And so if there were issues with the business, I'm certain that would be a part of our check at the division, is to make sure that it really is an Alaska business, so that they can benefit from the exemption.
Can you talk about what other states have done in terms of statutes and regulations?
Yeah, I know that, so 24 other states have done it. Actually, our proposal that we modeled ours after, we went and actually looked for the simplest one because we wanted it to be really user-friendly. Ours is based off of Alabama's crowdfunding statute. And I know that in other states, Oregon did theirs through rulemaking. They're getting they've had pretty good success. Last I had spoken to them sometime last year, they said that they had a good handful of them. Some states have implemented this and they've only had maybe 1 or 2 offerings. I think Oregon's probably a bigger success story. They have a lot of breweries that wanted to do crowdfunding that I heard, restaurants, that's sort of where the focus has gone. They have a very simple one as well, so I think that's sort of where we've seen that it's used. The more simple it is, the more it's used. I know Washington hadn't had one for a very long time. Theirs is very complicated. The form that you have to submit just to get it up and running is 36 pages long and requires audited financials and things like that. It's sort of similar to like a what's called like a score offering. So it's theirs is a little bit more less user-friendly, I would say. So we've seen that it's more successful, it's more used where it's simple and straightforward, which is what we think would probably be better for Alaskans. That we don't want to use these expensive portals or a complicated portal system. I think there's ways to ensure investor protection without making it so complicated.
So, just so I'm clear, so if you're an Alaskan company and you do a crowdfunding campaign and 9 of your investors are from Alaska, but then 1 is from out of the state, now it's an SEC interstate crowdfunding.
I think part of the problem, you wouldn't be able to necessarily start and then switch over because the SEC requires that you do it through those registered portals. And since Alaska wouldn't necessarily require that, I wouldn't see a situation where you would start a state and then transfer over. The SEC probably wouldn't accept that as. Okay, so you would kind of have to end it and start anew is what I would think.
So if you're raised in Alaska, then you make it clear from the beginning that it's only Alaskan investors.
Right, and that's the company's job to ensure that, because the person who wants to claim an exemption under the Securities Act, it's their job to make sure that they meet the requirements. So if one of the requirements is that you only sell to Alaska investors, you need to make sure that you are checking and assuring that people are residents, they have an address up here, at least doing some basic due diligence on your investors to make sure that you don't bust your exemption.
And do you know what the fee structure is going to be like on the SEC portal? Like how much are they going to take?
I'm not sure. I think that the SEC and FINRA, who will be running the portals, FINRA is the regulator for broker-dealers. FINRA is working on that rule right now.
Okay.
But I think it's a %. Yeah.
control over doing a state-run portal or privatizing the portal system?
None of the state proposals would prevent the use of a portal. So I wouldn't, based on what is being proposed, I wouldn't see why that would be prevented. And you could certainly also set up one through the SEC's process. If someone wanted to create a portal up here and have it accept through all 50 states, they could do that as long as they followed the SEC and FINRA's requirements. Yep.
You had mentioned in the legislation that's passed, is there a minimum or maximum buy-in for an investor? You mentioned like a $5,000 amount. Where did that number come from?
It's 5,000 maximum. That's pretty common throughout all of the states that have done crowdfunding. We've seen it lower. We haven't necessarily seen it higher than 5,000. It's sort of the idea that it's not supposed to be a large investment. It's supposed to be a investment from the crowd. Lots of small investments come together to help push one thing forward. So as you get higher and higher, I think there can be opportunities for potential higher risk to investors, obviously. There's investor protection concerns from our standpoint. And so, if you look at, I don't think any states are doing anything like 10 or higher than that. That just seems sort of outside the spirit of crowdfunding.
Sorry, it was 1,000 or 5%, whichever is higher, correct?
So under the Alaska proposals, it's 5,000 per investor, unless you're an accredited investor, which is that you have $1 million net worth, and that's really like high net worth investors. Then that's an unlimited amount that they can invest. But 5,000 per investor. The SEC is the one that has the percents, and I'll just look at that. So if your net worth or income is less than 100,000, it's 2,000 or 5% of the lesser of your income or net worth, whichever of those is greater. So 2,000 or the 5%, whichever is greater. And then if you make more than 100,000, it's 10% of your income or net worth, whichever is less. So.
Is the onus then on the entrepreneur or the investor to manage any taxable events that will come with investing in a company that already has a established valuation?
I would think if it was tax consequences of the company, that would obviously be the company's responsibility. If the investor is concerned about their own tax consequences, it would be their responsibility.
So it could be a company with that's pre-revenue or a company worth $10 million going into charges.
Right. So anytime you're thinking about investing, it's always a good idea, if you're concerned about tax consequences, to consult an accountant or your tax professional to make sure that that wouldn't adversely affect your tax issues.
I just want to say it's been great seeing the SEC, or I'm sorry, the State Division of Securities at several events like this for the last couple of years. You guys have done a great job getting out in the community and educating. So thanks for being active.
Yeah, it's always fun to do events. We do a lot of investor protection events, and so it's kind of fun to do entrepreneur events, because that's really another side of what we're all about, promoting economic development in addition to protecting investors. It's sort of like the two sides of our mission statement, so we really have to focus on both.
So given that PFD applicants are bona fide Alaska residents, can I apply to put my company on Give next year?
I think that's only available for charities. So that is sort of a form of crowdfunding, if you think about it. Yeah.
To do something, or if somebody had offered the question earlier about portals, it might be something to consider, how you might align a portal application to the PFD, so you might take your PFD idea, rather than spend it on Korean Samsung television, you might spend it on a promising Alaskan business.
Can I, just a really simple question that's probably pretty stupid, but, so if you're starting a company in Alaska, you are required to meet the guidelines of the federal SEC and the state body as well? Or is it just the state body if you want to practice business in Alaska?
There can be both. It really just depends, sort of. It's a very complicated question. Primarily, you're going to want to focus on state requirements first, because those are more likely to affect you as a local business. If you're doing the general kind of fundraising or capital raising that we see, that's going to be most likely dealing with our office. If there's any major federal securities red flags that we see, we may help point those out or suggest that you may be a little bit over your head and might want to get an attorney. And the security staff is here too. They're sitting in the front, so you can know who you're. These, raise your hands, guys, so that you can know who you'd be talking to when you call our office. It will be one of the 5 of us.
Do you foresee doing any more educational, if this goes through, do you foresee doing more educational workshops for potential investors? Because I feel like there's always so much interest for someone who invests in a company, and I think there's so much education that needs to come with that. Who's going to be giving that education? I'm really hoping we're not just pushing people off a dock here. Do you foresee doing more educational programs?
Absolutely. Yeah. And we are all excited to talk to investors or entrepreneurs whenever possible. So yeah, just invite us, just give us a call, and we'll be happy to.
You guys are thinking of starting or instituting more commonly that if this does go through?
I think that if this does go through, because this is sort of a major new thing and it's a big hot topic, I would expect that we would plan some events or possibly webinars or something like that, just to make sure that people really understand what the new rules are and make sure that you don't, go afoul of the rules.
There's one last question too. So each company that starts is going to have their own individual portal. Is that what you were saying?
No. So with the SEC situation, they're companies will be setting up these portals, and the way that it's supposed to work, from what I can tell, because nothing's happened yet, is that they'll set up these portals, and they'll be like, Kickstarter, but for investing. And so the place that runs the portal will be doing a lot of the vetting, making sure that the investors meet whatever criteria they need to meet, making sure that the companies meet whatever criteria they need to meet. For the SEC, they have to be U.S. companies. They can't be foreign companies, so that will probably be due diligence. So that's part of what you're paying for, I think, with the portal, is that they're doing a lot of this vetting. They'll be, channeling the money back and forth, and then but those will be for, it could be 100 companies on one portal, and then you go just like you would go on Kickstarter and see which one you like, and you would invest, and then that's how that would work. With the state here, you could do it more one-on-one through your own website. If someone wanted to set up a portal, again, I don't think it would be precluded by the law that a portal could be established up here. But we already see now that people are trying to find investors through the internet, through Craigslist, through their own websites. As a word of warning from the state, that is not permitted under current regulations, unless there's very, very limited ways that you can currently advertise. So, Craigslist may seem like a great idea, like, oh, that's really great, you can go out there and hit this marketplace and see if people want to invest in my thing. It's really something that we strongly advise against, and we do take enforcement action against that. But when this is in place, you could do that. You could go to a Craigslist, or you could set up your your own website and try to get investment that way.
Let me ask a clarifying question about your answer. When you say they, you're in regard to an SEC registered portal. This isn't a portal hosting being set up by the SEC. This is a third party who will take a commission for it.
Exactly. Essentially, they're like a new kind of broker. It's like a new kind of broker. Brokers, trade stock, buy and sell stock for the benefit of another person. They meet that definition, but they have set up a new type of broker just for these SEC portals. Are there any more questions?
What are some qualifications of this broker? I mean, what do they, it sounds like they have to have some knowledge of start a company and how to vet it. I mean, I'm curious what vetting process they would have to go through.
So they'll have to be SEC registered and registered through FINRA. That's a very stringent process that they'll be going through. I've just heard, I would think that it's currently established broker-dealers or people that have been looking at this since the law was passed in 2012 that have been setting this up. These are going to be very sophisticated companies for the most part. I don't expect that this will just be someone wanting to set up, this just like a guy that wants to set up their own portal. I mean, these are going to be large companies, and some of them may be brokerage firms already that will be setting them up. I haven't seen any yet because this hasn't gone into effect, so I don't know, but I wouldn't be surprised if you recognize names. Okay, well, thank you all for coming, and thanks for letting us come and speak to you all. And I have business cards up here, and you're welcome to ask questions after of me or my staff, and call our office if you have anything further.